are the components to contract? Always a contract is a voluntary agreement between two or more parties, which becomes enforceable by law. So minimum there must be two parties whenever you enter into a contract. That's fundamental. Second, one person has to make an offer. Like NawSeco made an offer saying that there are contract drafting codes for me. So that's called as proposal or offer. On the other hand, one of you accepted it and said that, yes, we are interested to join the session. That is acceptance. When offer and acceptance both meet together, okay, when two people have the same thought process. For me, it was a teaching. Like for NawSeco, it was to impart knowledge, and for you, it was to gain and enrich knowledge. When both of your intentions are same, we call it as meeting of minds. That is nothing but conscious and idle. So this is a legal maxim. Swati, please type it in the chat box. So meeting of minds is called as conscious and idle. Now, as a basis to both of this, you need to have a consideration. Means some money has to be involved. Like all of you have paid your fees. Some would have opted for EMI. Some would have opted like advance payment, like one-time payment. Some would pay in installments, however. But consideration is always an essence to the contract. However, there are few exceptions. Can you think of your exceptions where you can do a contract but no need to have a consideration clause? Any place where you need not have a consideration but an agreement gets executed. Think about it. Well, bill is basically not an agreement. It's basically a testament of a person. Gift deed, yes. And gift deed, never you will have a consideration called out. Next, NDA, non-disclosure agreement. Okay. So those places you never want to have a contract. Next is intention to create a legal relationship. As I told you, there must be a lawful object. Both of them have to legally engage themselves to discharge their respective duties. So these are the 4 points which is explicitly called out in the Act. Now, this three, what I've mentioned here is something which I have called out. Whenever you execute a contract, please ensure a certainty in your contract. Like, I am interested to do something. That certainty has to be very vocal enough. Like, I'm certain to teach. You cannot have any time of contract which is something up and running in the air. It cannot work out. Because never, if anytime there's an ambiguity or a confusion in a contract, discharging duties become very difficult. Therefore, please call it out certainly what needs to be done and what should not be done. Basically, a list of do's and don'ts. Next is commitment. Both the parties have to perform their duties. That is commitment. Like I should teach, it's my commitment. You should go to college. That is your commitment. So that is called as a commitment, which is very important, which has to be mentioned in a contract. Communication. Anytime you have a conversation, anything oral, written, please have a proper communication because that I may have a thought process in my mind and I may be doing in the same way. But is it reaching you? That's important. So periodically between the parties, it is recommended to have separate communications before executing the contract, during the contract, how exactly the work is going, any improvement is required. Have communication that will make you much more efficient enough to discharge your duties. Okay, so this is a basic components of contract. Clear on this slide? NDA by default, whatever you have your confidential information, that itself is consideration. You cannot value it. Maintenance of wife is always a separate maintenance need, which should be by the court order. So that is not technically in this concept because you're paying the money. So that lump sum consideration, what you call it as alimony, that itself is consideration. I will not be able to unmute at this point. Anything, please type in the chat box. Only at the end of the class, we will be doing it. Principal agent relationship, definitely money will be paid to the person. Employer relationship. Yeah, because the confidential data itself is money. That information itself is value. Okay. So in NDA, you will never have a consideration. You cannot have it also. To enter into contract, definitely. Consideration is one of the basic essentials to enter into contract as per Section 25. NDA, just hold on. We have a separate class on the NDA. Plus, when I'm doing a definitive checklist, I'll discuss more on NDA. Just hold on. Next one. Whenever you enter into a contract, there must be a valid reason, okay, to enter. First and foremost thing, we said under section 10, there must be a free consent between the parties. When do we say a consent is free? Number one, there must not be any sort of a coercion. Like, I am not supposed to tell someone, like, I'll keep a person on my gunpoint and say that execute a sale deed or you marry me. I'm just creating a threat atmosphere, a forceful atmosphere around a person and getting my work done. That is coercion and that is not acceptable. Next one. Whenever you are doing an undue influence, just pause, stop typing the questions at this point. Just focus on the slide. I'll come back to all your questions later. Undue influence. There are many people who use their power and position to influence other set of people and get the work done. Probably someone in a supervisory capacity, like a manager or an MD. He may use his power on his subordinates to get the activities in his favor. Initially, the classic example that contract law provides is in the Hindu undivided family. The Karta used to always influence the Pardanashini women. Like, women were not permitted to freely come out of the home and work. So they used to influence, and these women had to just listen to them. They couldn't voice out their opinion. So that is called as your undue influence. Fraud, intentionally, whenever you cheat a person, you know that a particular horse is dead, but you go ahead and enter into an agreement saying that you will help sell the horse to the person and take advance amount or take the entire consideration. That is fraud. Intentionally, whenever you cheat a person, that is not acceptable. Misrepresentation. Innocently, you make a statement. Like, you were thinking the horse is white in color, but by mistake in contract, you mentioned it as black in color. So that's an error that happened. You misrepresented it. Mere silence is also fraud when speaking is important. So anytime, innocently, whenever you make any sort of a statement, that is called as misrepresentation. Mistake. Two people are in two different mindset. Like, I said 8 p.m. today is the class, but you all got a notification or you all thought it is 9 p.m. class. So that's a mistake of basically. There was no intention to cheat anyone or anything. However, miscommunication did happen. A mistake did happen with respect to the facts. Whenever a contract is executed out of any of these reasons, that is by cheating or by undue influence, coercion, mistake, or misrepresentation, we call it as voidable contracts, which means the aggrieved party, means a party who suffered the injury, he can go before the court of law and cancel such a contract. By prima facie means on face of it, the contract is valid. No one will get to know that someone kept on the gunpoint and got the contract signed. No one will get to know that the husband used his influence over the wife to get a contract signed. No one will get to know. Outside world will not be aware of it. Only when you speak up and tell it, you can go ahead and make the contract void. Otherwise, prima facie, we consider the contract to be valid by nature. So therefore, we always say that the consent by the parties must be free and voluntary. Next one, parties competent to contract. I've already explained. Parties must be major, sound mind, and solvent. If you enter into a contract with minor, lunatic person, not only while entering, later also if the person turns unsound mind or insolvent, contract becomes void. Therefore, immediately it loses its enforceability and you need to terminate the contract. Always the contract should have a lawful object and consideration. Whenever I'm talking about consideration, it can be in form of cash or kind. Like, I may be in a residential apartment where I pay 25,000 rupees rent every month. I may pay in split, like 10,000 and 15,000, first 15 days and next 15 days. I can do. Or once for all 25,000 on the first day of the month I can pay. However it needs to be, I can certainly do that. So that is called as your consideration. Now, whenever I'm paying in kind, so you can pay in form of any coconuts maybe you have, or there are few people who take the property on lease and whatever income they earn out of it, they give. So that is also fine. So it is absolutely between the parties how they want to decide on the consideration. Past payment, future payment, lump sum payment, in cash, kind, fine. You can go ahead and do it. However, whenever you're giving something out of love and affection to another person, that is gifted. Consideration is not required. If I gift something to my mother, like a property which I have, it's my love and affection. I can gift it. Absolutely my choice. Or a non-disclosure agreement or confidentiality clause in any mail agreement. The entire details in itself becomes confidential. You cannot value the whatever is associated with that information. Like for me, like for example, for Google, maybe their upcoming AI, whatever information pertaining to how are they going to develop it, that's very confidential to Google. It may run in millions for them. But for me, who is a non-lawyer, so is a non-tech person, I'm an advocate who will never understand bits and pieces about AI. How does it work? What is the benefit? Because I am more like a layman when it comes to it. For me, the value would be like 10 rupees or it has no value in front of me. Okay. So that's why we always say that a confidentiality cannot be valued only when there is a breach. When someone breach your confidentiality, when someone fail to fulfill that confidential information, then a damages will be attached to it. What is breach? What is obligation? What is damages? In your class 5, we'll discuss. But now I don't want to take much time on that. So this is on your consideration. Anytime you enter into contract, consideration is one of the operative clause which should be there. Object, as I told you, there should be a lawful object. You can never enter a contract to kill someone, immoral activities, illegal activities, to stop someone to get married or to say someone should get married to you. Such contracts are absolutely void ab initio. So these are the conditions that you need to adhere to in order to make your contract valid.